Um, eh, Today we are going to talk about motions in limine. As usual, as you can see here, I've got my usual disclaimer. Happy to take any questions that come up during the program. I may this time wait until the end, kind of depends on timing. But if you have any questions during the course of the program, I'm happy to answer them. However, because I'm a quasi-judicial employee and am covered by the rules of professional conduct, I cannot answer any questions concerning any cases that are currently pending in the Contra Costa County Superior Court. I also, nothing that I say here should be construed as an indication of how any judge might rule on any particular issue. And of course, everything that we talk about here in terms of fact patterns and example forms are completely fiction and have no basis in fact. There we go. And here we go. I've got your abbreviations that we've seen in the materials from the past, and we all by now with episode 5 are familiar with the fact pattern that we are dealing with when we talk about our examples. So today, as I mentioned, episode 5, we're talking about motions in limine. In limine is, of course, Latin, which means at the very start. For those of you that don't know me well, it is my lifelong professional goal to eliminate as much Latin as I can in legal writing. But there are certain things that we can't avoid here. In limine is one of those things because it's so often used that it's become a term of art. So we talk about motions in limine, which means motions at the very start of a trial. Now, there is no express authority in either the Code of Civil Procedure or the Probate Code or the Civil Code or the Evidence Code that authorizes motions in limine. It is a procedure that has developed over many, many, many years, both in federal and in state court practice, that has become really an important component of trial practice in all areas, civil, criminal, where it becomes very, very important, particularly when we're talking about jury trials. Now, of course, in probate practice, we don't have jury trials, except for very, very limited exceptions, which we'll talk about in a moment. Now, the purpose of motions in limine, the primary purpose and the reason why it was developed is to prevent a jury from hearing inadmissible evidence. Now, jurors, being usually non-trained lawyers, do not have the training to be able to parse out what might be admissible or inadmissible. And so typically motions in limine are heard outside the presence of a jury, and really the more important evidentiary issues are resolved prior to the beginning of trial, so that the court doesn't have to deal with the problem of unringing the bell when inadmissible evidence is presented. Now, it's certainly trial court can instruct a jury to ignore inadmissible evidence, but sometimes it's so important or prejudicial that you just can't expect an untrained set of jurors to actually ignore something that they actually heard in court. We also, the purpose of motions in limine is to avoid wasting trial time on the presentation of otherwise inadmissible evidence. And to a certain limited extent, you use a motion in limine to set some trial procedures. We'll get to that in a moment. Now, in court trials, they can be useful. Certainly when I started in practice, the traditional view of motions in limine in court trials was that you don't file them. Judges don't pay attention to them. Judges know how to deal with the rules of evidence. And if you tried to file a motion in limine, you get this strange look from the judge, and they will just simply be denied and dealt with during the course of the trial. However, in certain circumstances, especially as time has gone on, I have found that trial judges have become more and more receptive to entertaining motions in limine, particularly when we're dealing with larger evidentiary issues or issues that might take up a lot of trial time, where if the motion is granted and evidence is excluded, you can literally, streamline the trial by days if you have a successful motion in limine. And so you'll still see, however, a lot of judges deny, I would say, most motions in limine without prejudice, and then deal with the evidence issue once it comes up during the organic course of the trial. And like I said, others will deal, especially with the larger evidence issues, on the merits as they are filed. Now, generally, you're going to want to ask your trial judge or to consult your local rules regarding the receptiveness to motions in limine in court trials. Here in Contra Costa County, both of the probate departments will entertain motions in limine and rule on them if it's appropriate. Again, the tendency is to deny without prejudice, but there will be certain instances where the issue is so important that it does deserve an advance ruling. Now, because they are usually denied without prejudice, you may still feel it's useful to file motions in limine as a matter of strategy in order to give the trial judge a heads up on an anticipated evidentiary issue that you expect to come up. Now, that does not mean that your motion in limine is meritless, even though you think it's going to get denied without prejudice. I want to be very clear about that. It is, I think, not an impermissible strategic device to say, hey, look, judge, you're going to get this. We're previewing this. I anticipate raising an objection, but at least now there's a brief in place for the court to consider when the evidence comes up and can rule on a more informed basis at the time the evidence is presented at trial. Any evidentiary objection that could be raised at trial can be raised by a motion in limine. Does that mean that you should raise every evidentiary objection in a motion in limine? Of course not. You really want to be strategic about what you raise in an in limine motion. You want to raise, if there are privilege issues, we'll talk about those in a moment, that are really important. You may want to raise those early. If there are, if you are seeking to exclude, for example, a witness from testifying on a particular basis that might take up 2 or 3 trial days, you might want to raise it at that point, so that at least you can get the trial judge thinking about your evidentiary issue. Another type of common motion in limine is to exclude a non-party fact witness from the courtroom until after the testimony is offered. This is very, very common, and I've seen it raised as a motion in limine multiple times. Again, you want to consult your local practice. If you are in either this court or in another county court, you consult with your trial judge or perhaps even local rules to see if there is perhaps a standing order that would exclude non-party fact witnesses from the courtroom until after testimony is offered. A slight variation on that theme is to exclude expert witnesses from the courtroom until the opposing expert is on the stand to testify. The idea might be that an opposing expert would need to hear the opinion of the opposing expert witness in order to be able to rebut the opinion when it's time for the opposition to present its case in chief. That would be entirely appropriate. But again, you want to be careful about whether or not to raise that as a motion in limine in the event that there might be an existing standing order for your trial judge. So some good examples of reasons why you might want to present a motion in limine is to prevent the introduction of irrelevant evidence under Evidence Code Section 350, to prevent unduly prejudicial evidence under Evidence Code Section 352. Obviously, that's a big deal. 352, you use to exclude evidence that might otherwise be relevant and admissible, but becomes unduly prejudicial to your client. Now, that might be one word of caution there. Again, you're dealing generally in probate with a court trial. And so raising the unprejudiced, the 352 objection, the court might take that kind of emotion limiting and say, well, look, I want to hear the evidence, and then I will determine perhaps whether or not it should be entitled to the full weight that is advocated for the evidence, or, make a decision at the time the evidence is presented to make a ruling on the motion. So that one is a real right issue for a court to say, look, I'm going to deny without prejudice until we get there. Raising issues of privilege. It's a big one. If you anticipate the other side is going to present evidence that might violate the attorney-client privilege or a doctor-patient privilege, that is an absolutely important one to consider and would be certainly something worth discussing with the court in a motion in limine. If there is you've discovered that there is an intent to present evidence of an offer in compromise under Evidence Code set that is protected from being admissible under Evidence Code Section 1152. That's a big one as well. Again, that's you can raise that and the court would likely consider it. Another one could be seeking to exclude the testimony of an expert witness because they are not qualified, which we will talk about here in this slide. A little bit out of order there, but testimony of an unqualified expert witness under Evidence Code Section 720 or 801. Again, you're going to be seeking to not only save trial time here, but also if you are seeking to present an opposing expert, you're going to save on the expert witness fees if you're able to disqualify or to prevent the opposing expert from testifying because they're unqualified. Character evidence, you can certainly raise it as a motion in limine, but again, the court's going to probably want to hear the evidence and make a ruling at the time. That's a little bit less certain that the court would entertain the merits of that kind of a motion. Another big one, and I've actually seen a motion in limine like this in pretty much every trial I ever prosecuted. A motion in limine to exclude evidence that isn't disclosed in discovery when it's required. If you have specific categories of evidence that you think the other side might be sandbagging you on, you will want to list it in your motion in limine. And certainly present the discovery responses and efforts that you have made to enforce the discovery before you can really convince a court to grant a motion in limine on this ground. And when I say really trying to enforce the discovery, I would certainly include attempts to obtain information through written discovery, through deposition, through supplemental discovery. You may be aware that under the Civil Discovery Act, for interrogatories and requests for production of documents, you have the right to seek supplemental discovery. The responding party is not under an obligation to continually update their discovery responses. It is up to the propounding party to serve supplemental discovery to say, hey, look, if you have submitted discovery responses and they're no longer accurate, you need to make them accurate. You can do that twice before trial is set and one other time after trial is set. So really, if you're going to try and exclude evidence because discovery was not provided, you really want to make sure that you've demonstrated to the court that you've taken every possible discovery avenue you could in order to get all discovery information disclosed from your opponent before you file a motion in limine and have the court grant it. It really would benefit you to put in that kind of work from an evidentiary standpoint. Going back to the expert testimony of an unqualified witness, it's sort of whether or not a court would entertain that as an in limine motion or wait until it's time for the witness to come in and testify is sort of going to be obviously up to the judge. If you have really good expert witness testimony to indicate that the expert witness is in fact unqualified, you could present that through the deposition testimony. However, oftentimes that issue is resolved during the expert witness's voir dire, where the proponent of the expert witness is asking questions concerning the qualification of the witness, and then the court can rule on the objection at that point that the expert is unqualified. I'm going to answer this question from Rita. What if the opposing party stated in their answers to interrogatories that more information will be provided as it is received? First of all, that's an improper response. That's objectionable, in my opinion. The respondent to discovery is required to provide full and complete responses to all discovery requests as it is at the time that they provide the response. It again is up to the propounding party to, I'm going to put the question over here. It is up to the propounding party to ensure that the responses are supplemented. Again, the responding party does not have an obligation to update their discovery responses. And so the appropriate counter to a motion in limine preventing the disclosure of undisclosed evidence is to say, hey, look, you know, yeah, I told them I was going to update as it's necessary, but you didn't ask, and you had the opportunity to ask under the Discovery Act. I would not rely on that kind of a response to and count on a court to grant a motion in limine on that basis. Well, what the heck? How do you address an expert witness testimony that they cannot provide all opinions they plan to offer at trial at the time of their deposition, and their testimony that they plan on doing additional work to form their opinion after their deposition? Is that best addressed in voir dire or a motion in limine? I would address that in a motion in limine, and then at the expert witness deposition, I would ask, what do you need to do in order to complete your opinion, and then confer with opposing counsel to ensure that you can continue to take that expert's deposition so that you can get all of their opinions on the record, and because that situation to me seems like sandbagging, to be candid. I know it happens all the time, but you know, if they need to do more work, remember in the expert witness disclosure, they are obligated to state that they will be ready to present all of their opinions at the time of the deposition. And so that to me sounds like, you know, more like an attempt to evade the discovery obligation to disclose all opinions that they intend to be presented at trial. If you get that response, be willing to take additional depositions, even if it means moving to compel and having the other side pay the expert witness fee, because again, that's an expense. But you want to make sure that you get each and every opinion that you can in discovery before you get to trial. And then if you still get sandbagged like that or stonewalled, then I would bring it up as a motion in limine and seek to exclude all of the opinions that were not disclosed during the course of discovery. Those are really good questions. All right. What are inappropriate uses of motions in limine? You may not use a motion in limine as a substitute for a motion for judgment on the pleadings. However, you can move to exclude all evidence either in one motion in limine or in multiple motions in limine, and then let the court decide whether the result is a dismissal or a default. In a court trial, I would expect a judge to not be terribly receptive to this strategy. for a couple of different reasons. Number one, court's going to want to hear from witnesses, and then especially on the petitioner side, and then entertain a non-suit motion, which we will talk about next week, rather than resolve a lawsuit before any evidence is presented. You're at trial, the court's expecting to hear from witnesses, and the court's going to want to at least be able to show the Court of Appeal that there was real evidence considered, and at least possibly through a non-suit motion, the court makes a decision that trial need not continue. Another inappropriate use of a motion in limine is to control ordinary procedure and matters of professional courtesy. For example, and this is the Kelly case that I'm citing for you right here. There was a motion in limine filed seeking an order to require trial counsel to list exhibits that are to be offered in the next day at trial. Those kinds of matters are to be addressed informally and orally in court, not by a motion in limine. These are matters that are of professional courtesy. The court will expect you guys to meet and confer with your opposing counsel in order to address those kinds of issues. The other way that it could be resolved is take a look at, perhaps a pretrial order or or local rules. I have seen some pretrial orders or local rules that would require counsel to meet and confer for that purpose. And so normally those kinds of issues are not appropriate for a motion in limine. All right, so what's the procedure? How do you go about doing a motion in limine? Well, it really depends. As I said at the beginning, there is no statutory authority for motions in limine in general. Sometimes you file and serve on the first day of trial, sometimes up to a week before, sometimes at a pretrial conference. It really depends on your trial judge, and it really depends on your court. And so you will want to absolutely follow those procedures. Generally speaking, the motions are in the same form as ordinary law and motion matters, but they are usually far more brief because the issues are very narrow. They are purely evidentiary issues, but they still need to be supported by evidence. You should usually comply as closely as possible with the normal law and motion format. You might see secondary authority suggest that there would be a formal briefing schedule that is similar to what you would see under CCP 1005 or 1013. That's not necessarily true. It is all really going to be controlled by your trial judge or your trial court, either through local rule or a pretrial order. All right. As per usual, I've got a sample form here for what motions in limine might look like. Now, please take notice of the note up at the top. This is one of many different kinds of forms that you could use for motions in limine. In my practice, when I was in private practice, I would do separate motions in limine, but it would be a single document with the notice, the points and authorities, and the declaration in one document. That is an exception to my personal rule of thumb, where I would submit motions in separate documents. Notice is one document, points and authorities in one document, evidence in another document. Only because generally these issues are so narrow that it doesn't make a whole lot of sense to flood your trial judge, oftentimes on your first day of trial, with a whole bunch of documents, especially if you're doing multiple motions in limine, for the court to consider. It just becomes unwieldy. Remember, this is something that is to be done usually quickly at the outset of trial, that can be addressed so you can move on to the presentation of evidence in cases in chief. So this first page would be sort of your notice of motion, where you're giving out the grounds, and I've got three motions in limine here. Very simple. As you can see here, Evidence Code section 352, you always in any notice of motion, you need to cite the authority upon which you are filing your motion. Without authority, you cannot get your grant. As we have seen in other law and motion matters, you've got the description of the documents upon which your motion relies. Again, very, very, very important. If you surprise the court with a document that isn't part of your motion in limine, you're likely going to get denied. You've got your points and authorities. Again, very simple. You all know how to do points and authorities. Make these brief and really focus on the evidence code. Evidence code is going to be really key here that justifies a grant of a motion in limine. And then we've got your evidence. Here you might attach deposition transcripts, discovery responses, things of, and that's typically what you're going to be using to support your motion in limine, because you would expect that discovery responses are going to indicate what your opposing party is intending to present as evidence at trial. Again, very simple. You certainly could present them as separate documents, each motion sequentially numbered, and usually you will see local rules that say motions in limine must be sequentially numbered as separate documents. That's perfectly fine. Courts are entitled to do that. If you are opposing a motion in limine, you know, it really sort of depends on the timing. In a court trial, if you are required to present motions in limine on the first day of trial, you really don't have a reasonable opportunity to present a fully developed opposition. If you can find the time to do it, I would recommend doing it. Again, make it short, make it simple. If you need to meet and confer with opposing counsel, I would do it. But again, there is no real format rule that applies to your motions in limine. Again, they're very simple, nothing, you know, really exotic, and again, really very focused on the evidence code.
I don't know. I have a bad feeling about this.
So I ran out of intelligent or clever things to say about motions in limine. I'm going to be perfectly honest with you all. They're pretty basic, and at least in probate practice, they are most often denied without prejudice, so that the court can consider the evidentiary issues during the course of the trial. But I need to fill in more time, because you are all entitled to an hour's worth of education. So those of you that are familiar with the law, with the Star Wars universe, we've had a couple of one-off movies that aren't in the episodes. This one we're going to be calling Rogue Decision, a law and motion story. We're going to talk about statements of decision. I know this is a left turn for all of you. Again, motions in limine, I thought I could fill in more, but I couldn't. So, you know, when I originally pitched this series to Oliver Bray from the Bar Association, he asked whether I would be including information about the rules governing statements of decision. And since I had some time, I thought I would do a Rogue One sort of thing and talk about them here. So that's what we're going to do. Statements of decision, and again, I apologize. I know this is a surprise even to the Bar Association, but you know, we'll get through it. The authority for statements of decision, CCP 632 and Rule of Court 3.1590. Statements of decision replace the old findings and fact and conclusions of law. And what we are dealing with here is an incredibly archaic procedure, really, that is derived from a bygone era. And in court, it is used in court trials only where the case involved the trial of a question of fact. And the purpose of the statement of decision is to explain the factual and legal basis for the court's decision as to each of the principal controverted issues at trial. Kind of sounds like findings of fact and conclusions of law, doesn't it? It's largely the same, but the procedure is really, really cumbersome. So procedure and timing on a statement of decision. You've gone through trial. You've presented all your evidence. Now, getting a statement of decision requires a timely request, and being timely is really the only indispensable requirement for getting a statement of decision. And really, the timing of the deadline for a request for statement of decision really depends on the length of the trial. If your trial was less than 1 calendar day or less than 8 hours over more than 1 calendar day, you must make your request for a statement of decision before the case is submitted, meaning submitted for decision. If your trial was more than 1 calendar day, you are required to get your request for a statement of decision within 10 days after the tentative decision is announced. And I've given you the authority for those timing issues. Now, the last slide, we talked about a tentative decision. So what is a tentative decision? The tentative decision is literally the court's conclusion after considering all the evidence. It is literally who won, who lost. And that is really all that is required of the tentative decision. The tentative decision may be made orally or in writing, but if the tentative decision is made orally, the court clerk must serve the minute order on all of the parties that reflects the tentative decision. And so I candidly have never seen or been part of a trial that included an oral statement of decision. Excuse me, but I can certainly see one being made on a trial that lasts less than 1 day. I think that would make all the sense in the world, but that doesn't necessarily mean that one would happen. It's really up to the trial judge. Very, very importantly, the tentative decision is not binding. It is not the judgment. Only the judgment is binding. So when the court makes its tentative decision, it has 4 options under Rule of Court 1590C. The tentative decision can state that it is the statement of decision subject to later objection by the parties. It can indicate that the court will prepare the statement of decision on its own. It can order a party to prepare the statement of decision, and usually that party is the prevailing party, the party who actually wins on the statement on the tentative decision, or it can direct that the tentative decision will become the statement of decision unless within 10 days of the announcement of the tentative decision, a party specifies those principal controverted issues as to which the party is requesting a statement of decision or makes proposals not included in the statement in the tentative decision. That's the language of the rule. You can see why it is so confusing. Now, whether or not the court decides to choose any one of these options, it is entirely up to the court. I have seen judges draft their own statement of decision, their comprehensive statement of decision, really because the court felt that it could do it better on its own than the parties, and that's perfectly acceptable. The court can again, order a party because the court is just frankly too busy to write its own statement of decision. And really what the statement of decision would be is more than who wins and who loses. If there is no timely request or if the request is waived, there are some very important rules that apply. The first is all objections to the court's failure to make all findings necessary to support its decision are waived. In other words, no party can later come back and say, hey, look, your decision was wrong because you didn't consider evidence X, Y, and Z, which would require you to change your decision. Those kinds of issues are waived if you don't have a timely statement of decision. Second, and perhaps more importantly, especially to parties who decide to appeal the court's judgment, is that the Court of Appeal will apply what's called the doctrine of implied findings, which means the Court of Appeal will presume that the trial court made all necessary findings supported by substantial evidence. Now, most trials that actually go to trial and are and reach judgment, if they are appealed, most of the time where there is any conflict in the evidence, the Court of Appeal is going to use the standard of review of substantial evidence. In other words, the court might disagree with the Court of Appeals might disagree with the trial court, but because the judgment is supported by substantial evidence, the Court of Appeal will affirm. This is an extremely important effect. If you have an issue where you might appeal the decision, you need to request a statement of decision so that the Court of Appeal can consider your arguments that are made in connection with the statement of decision. So how do you request a statement of decision? What form must it take? The person requesting the statement of decision must set forth the principal controverted issues that should be included in the statement of decision. Now, in practice, I have seen and I have made requests for statement of decision just by saying, I want a statement of decision. And that sort of implies that every principal controverted issue needs to be included in the statement of decision. But the rule requires it. However, we're dealing with rules of court, not with the Code of Civil Procedure. The court does have some discretion to ignore its own rules. I would not, if you are in a position where you are going to ask the court to provide a statement of decision, I would ask either for an opportunity to list out the principal controverted issues in writing or list those orally in court for the court to consider. If you're at a long enough trial, you're probably going to have a court reporter there anyway who can take down the list of principal controverted issues that are set forth in your request for statement of decision. After a request is made under 3.1590D, any other party may make proposals as to the content of the statement of decision within 10 days of the first request, and that is 10 calendar days, not 10 court days. I see that there are questions and answers or questions. I do see them. I'm going to get them at the end, just so that I can finish it up. But thank you. I will get to them at the end, I promise. So, preparation of the proposed statement of decision. If the court decides to do it, the court must prepare the statement of decision and propose judgment within 30 days of the tentative decision. Or, if the party is ordered to prepare it, it must be filed and served within 30 days of the tentative decision. And if the statement of decision and proposed judgment are not timely submitted, any other party may either prepare it themselves or move for an order deeming the statement of decision waived. Now, this timing is often a source of great confusion. If you are in court during the time that the statement of decision is to be prepared, it makes sense to me to ask the court for clarification on the deadlines. You also certainly have the opportunity to request extensions of time, and the court has the discretion to grant it for good cause. Again, we're dealing with the rules of court here, not with the statute. So in my experience, judges are pretty lenient in being in granting extensions of time, with the exception of the deadline to actually request a statement of decision. If you blow that deadline, you're likely going to not get your statement of decision. But in terms of preparing it, especially if you've had a lengthy trial with a lot of evidence, the court's probably going to be pretty lenient in granting extensions of time in order to get this right. Remember, the statement of decision is actually the court's statement of why one party won and the other party didn't. And so the court certainly wants to get it right if there's any prospect of appeal. Objections to the proposed statement of decision. Any party may object to the proposed statement of decision within 15 days after the date the proposed statement of decision and judgment are served. The form of objection, you must show in your objection that the proposed statement of decision either does not resolve a controverted issue, is ambiguous, or relies on facts that were not proved or are outside of the record. This, especially number 3, is where you're going to get the most mileage out of your statement of decision. Even if the trial court disagrees with you on your objections, those issues are preserved for the Court of Appeals to consider and examine. So if you're in a situation where you came up, where you're on the short end of a trial and you want to maximize your chances of reversal up in the Court of Appeal, this is where you're going to get your maximum mileage, is really pounding away at the statement of decision and letting the court know that, hey, I think maybe you got it wrong. Obviously, you want to be gentle because you don't want to, have the court be upset with you ever. But you really want to be able to point out to the court, hey, you got it wrong, and here is why. The content of the statement of decision requires the factual and legal basis for the decision. That's under the statute. Those are required under CCP 632. The court does not need to address all of the legal and factual issues that are raised by the parties, but only the grounds upon which the judgment rests. That should be rests, without necessarily specifying the particular evidence considered by the court. The court can, and in my experience usually does, specify the evidence. It really makes for a more complete statement of decision that can be considered by the Court of Appeals. In addition, the court need only set out ultimate findings rather than evidentiary findings. For example, the court might include in the statement of decision facts that support that a trust instrument is invalid due to lack of testamentary capacity. The statement of decision. The statement of decision could and should specify what the applicable law is, whether it's testamentary capacity rather than contractual, for example, and then support the ultimate decision. Again, usually, especially if you are drafting the statement of decision by order of the court, you want to include the key evidentiary facts that support the ultimate conclusion, but not every fact. So that's extremely, extremely important. The statement of decision, by the way, does not need to be, does not need to cite to, for example, trial testimony, from the trial transcript. That is not necessary. The trial court does not need, or the statement of decision does not need to attach any evidentiary documents, although in my opinion, it should at least reference the evidentiary documents by exhibit letter, or if available by Bates number. That would be, I think, important. And so really the bottom line is, if you are drafting, you want to make it as complete and bulletproof as you possibly can. One thing that does not need to be in a statement of decision is anything on an attorney fee award. It is not required. We will see in the next episode, in episode 6, that attorney fee awards are typically left to post-judgment motions. You can certainly include in a statement of decision a decision that a party is entitled to an attorney fee award. I have certainly seen that, but usually I have seen that the statement of decision say, plaintiff or petitioner is entitled to an award of attorney's fees to be determined after the filing and determination of a motion for payment of attorney's fees after the entry of judgment. Finally, the court, before entering the final statement of decision, always has discretion to order a hearing regarding proposals and objections to the statement of decision, and also the proposed judgment. That's under Rule of Court 3.1590K. The purpose of that hearing is to really iron out whether or not controverted issues have been addressed and resolved and are put into the statement of decision as appropriate. Now, as a practical matter, again, I've never seen a court have a hearing on the proposals and objections to a statement of decision. I personally cannot think of a reason why a court might want to do that unless you might have a novel issue of law that needs to be addressed or maybe fleshed out a little bit more. However, with court trials, it's been my experience, especially in, say, the last 10 to 12 years, that what courts are doing, instead of hearing oral closing arguments on longer trials, the courts are asking for written closing briefs in lieu of an oral closing statement. It would be in that context where you are going to really flesh out all of your legal arguments for the court, so that the court can then use those written briefs, which leads to your tentative decision, which leads to your statement of decision, and finally to judgment. And so, again, because in court trials, those issues are going to be fleshed out long before the statement of decision is made, I don't see a need for generally a hearing on a statement of decision. Again, the reason I wanted to even talk about this at all is because this is a really archaic procedure. The rule of court reads like mud. I created a spreadsheet not long ago that looked like not a spreadsheet, but a flow chart for statements of decision that looked like a 3-year-old decided to take crayon and just draw lines and boxes and diamonds. It just makes no sense. But really, in my opinion, the key to the procedure on statements of decision is in the tentative decision. What is the court ordering the parties to do, or is the court ordering the parties to do anything in terms of drafting the statement of decision? Once you get really to that point, the procedure becomes a little less cumbersome, and then you get to the judgment, and then you can move on to post-judgment matters. I have completed what I need to talk to now, and so we are going to go to questions. First, anonymous attendee, do you think that pocket briefs can be worthwhile on anticipated issues that come up? Are there concerns about being able to allow a written opposition? The first question, pocket briefs are great. Have them handy in your trial binder, but don't necessarily file them with your trial documents. What you'd want to do is raise the issue with the trial court, whether it's in a motion in limine or whether it's in a pretrial conference, and then you can indicate to the court, hey, I have a pocket brief ready for your honor to consider once the issue comes up. I'm happy to file it at your request, and leave it up to the court to determine whether or not the judge wants the pocket brief to consider. Are there concerns about being able to allow written opposition? Courts will always allow a written opposition. One thing that in my experience courts don't like is one-sided arguments. If the issue is important enough that would require briefing from one side, the court's going to want briefing from the other side. There's no easier way for a court to get overturned than by preventing the other side the opportunity to give a meaningful opposition, meaningful and considered opposition to an argument, especially when that's presented in writing. So that would be my thoughts on that. Is the court required to issue a tentative decision? Absolutely not. There is no requirement. The court can simply enter. So here's what happens. The court announces a tentative decision. Nobody asks for a statement of decision. Court enters judgment. That's literally the end of it. And then the Court of Appeal then assumes that the judgment is entered and was supported by competent evidence, and you've just very easily gotten yourself way ahead of the game in terms of having your judgment affirmed on appeal. So the clear answer to that is no. Do these statement of decision principles apply also to law and motion orders or case management probate hearings where the court made oral orders that might be appealable? So I have to tread a little bit lightly on this for reasons that I'm not going to discuss right now. My opinion is that where a court makes an order on a law and motion matter, put aside the context in which it is, or a pre-trial law and motion, an interlocutory order, the court is not necessarily required to draft a comprehensive order. Normally on dispositive motions, certainly as we discussed on summary judgments, the court is required to talk about if a motion is denied, what triable issues of material fact exist that lead to the denial of the motion. Demurs, the court is required to talk about the reasons why a demur is sustained or overruled, and I'm forgetting the precise language of what the requirement is. But you know, there are certain statutes that require findings on an order, except to the extent that a statute requires certain findings on an interlocutory order. No, the statement of decision rules don't apply to interlocutory orders. Rule of Court 3.1590 only applies to statements of decision after a court trial. But that being said, as a practical matter, courts are going to give you a comprehensive order, and it would not necessarily result in reversal if you get an order from the court that doesn't follow these principles. You're also going to be in a position where we talk about appealability. 9 times out of 10, your interlocutory order isn't going to be appealable. You might take a writ, and those are pretty rare. I'm particularly referring to a timely request for statement of decision in probate case management hearing. So I'm assuming, because I've got 3 anonymous attendees giving me these questions, if a timely request for a statement of decision is made, yes, the court is required to make a statement of decision. And I hope, I'm assuming that this is from 2 questions before here for y'all to see there. That is my assumption. So if a timely request is made, yes, the court is required to give a statement of decision. The court would be reversed if one was made and it was not given. What is a pocket brief? I'll get to you in a second, Doug, and the anonymous attendee above you. What is a pocket brief? A pocket brief is So let me give you an example. You have an issue that you don't necessarily think is appropriate for a motion in limine, but might come up as an evidentiary issue later on in trial. In other words, it's, you know, it's something that might even come up in trial, where you think, hey, there's an evidentiary hearing or there's a legal argument here within the trial that the court might want to consider to assist in evidentiary hearings. You can anticipate those issues coming up. Say, for example, I'm going to give you another example. Say, for example, you have evidence that you're not sure the other side is going to present at trial. Only when they presented at trial would you want to consider making legal arguments concerning its admissibility. You might have a quick legal brief at hand, ready to go. Say, hey, judge, in order to help you with the argument, here's a brief. Would you be willing to consider it? That's sort of a pocket brief. It's also something that, you know, even in terms of a memo that you might have for yourself, to have in hand to assist in making a legal argument. I see a hand up for Joel Zabrak. Go right on ahead.
Yes, I may be premature by a week, but I have a question about e-filing. I'm wondering if there's a way to expedite processing of an e-filed petition for letters to get the file number and a hearing date so that the administration of the estate is not prejudiced by delay.
That is not something that I can answer in this series. Certainly in context with the Contra Costa County Probate Department. I will tell you what I have told others is that we do have problems getting filed endorsed copies in the electronic filing system, which has been up for about a year. If you want to ensure that the court sees your filed document and you're butting up against your hearing, and you see that it still hasn't appeared on Odyssey, make sure you provide courtesy copies, hard courtesy copies, at least 3 court days ahead of time. That's the best advice that I can give you. If you're responding to tentative rulings, there's a requirement that you clear them 3 court days, or is it 2 court days, whatever it is, 2 or 3 court days before the hearing. And if you want us to see it, it very likely isn't going to end up in Odyssey, but give us courtesy copies. It certainly defeats the purpose. I get it. But that's the best advice I can give you until further notice. One last question. In a probate hearing for discovery sanctions, for example, could a party request for a statement of findings? If so, what's a timely request? The answer is no. The court's going to, generally speaking, prepare its own order. I can speak to Contra Costa County. I can't speak to other courts. In the Contra Costa County Probate Department, the courts prepare their own orders on law and motion matters like this, and they're generally going to be comprehensive, and you're going to get it prepared by the court and sent out. Remember what we're talking about in all the way back in episode 1. If you're in the civil department, you are going to be given a tentative ruling, a comprehensive tentative ruling on the merits that you will see posted the day before your hearing. And so if you have a problem with any portion of that order, you have to call in, contest the ruling, and discuss it at the hearing with the judge the following day. But you will get an order, certainly in probate, that the court feels is appropriate, and there is no need and no real, I mean, if you're at the hearing, you want to ask for a comprehensive order, you can ask for it. Whether or not the court gives it to you is up to the court's discretion. Would you rather fight 10 Grogu-sized Mandalorians or 1 Mandalorian-sized Grogu? 10 Grogu-sized Mandalorians, because I'm afraid of the Force, because I think the Force can kick my butt. Which spin-off movie from the 9 main Star Wars movies is your favorite and why? Rogue One, simple, because it's just good. And then, you know, that leads into Andor. It's just wonderful. Really, really good stuff. Hey, folks, thank you. My time is up. I thank you once again. I look forward to seeing you next Tuesday for the final episode of the series on post-judgment orders and motions. I look forward to it. Have a great day.
Thank you so much, Mark, and thank you everyone for attending today. I won't be here next week. You'll be with Ann Wolf next week. So I'm here to help if you have any questions until Friday. If anything comes up next week, if you don't get the link, anything like that, please email Ann Wolf for your seminar, your webinar next week. Look for your attendance certificates and materials in about 7 days via constant contact. And I think that'll do it. Thank you guys so much for attending, and thank you again, Mark.
Mark, Sarah, on behalf of the Estate Planning and Probate Board, thank you.
Thank you. Bye-bye, everyone.